So the first case to come before us this morning is State of Ohio versus Wesley J. Morehead. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time, let me know when you get started. Keeping the clock, you can also see it on the wall up there. Please don't use the names of any victims or minors. The judges have read your briefs and we are ready to proceed when you are. Would you like to reserve any time for rebuttal?
Yes, good morning, Your Honors. I reserve 3 minutes for rebuttal.
Thank you.
Thank you. Your Honors, may it please the Court, my name is Hector Martinez. I represent the appellant, Wesley Morehead. This Fourth Amendment explicitly mentions houses. The United States Supreme Court has consistently upheld the greatest protections from warrantless searches for our houses. Here, the City of Medina Police Department violated Mr. Morehead's right to be free from a warrantless search and seizure of his home, and the trial court erred in not granting appellant's motion to suppress evidence. Your Honors, the key facts in this case that I wanted to point out were, number one, the fire was at 1013 Sugar House, not 1021 Sugar House, Mr. Morehead's residence. There was no emergency affecting life or limb at Mr. Morehead's residence at the 1021 Sugar House Lane. Officer Deeks and Sergeant Wagner, who testified at the suppression hearing, testified they were not wearing any protective equipment for smoke inhalation. Officer Deeks did not observe or detect any smoke at 1021 Sugar House Lane. He also testified that the windows were secure. It was January 3rd, 2021, a day not unlike today. Also, Officer Deeks testified he did not observe any damage to 1021 Sugar House Lane from the fire located next door. Officer Deeks also clearly stated on his body camera in State's Exhibit 1 that he heard a radio. He did not hear voices from it inside the home. He testified, and it's on the Exhibit 1 on his body camera, that he heard a radio from inside the home. Let's talk a little bit about the dog. The dog can be viewed on State's Exhibit 1. The dog is not in imminent danger or peril. The dog's just laying there. It's not agitated or disturbed at all. Also, there's no objective signs or reports of an emergency in the home. Talking about the dog, the sirens are clearly audible. There are neighbors milling around. Anyone on that street would have heard the sirens and noticed that there's an emergency and come out of the house.
Counsel, I just wanted to make sure they were clearing the houses on either side of the home that was on fire, right?
That appears to be the case, Your Honor.
So your client's home was treated no different than the other home?
It was not? No, it was not. Well, it was. We don't know if they went inside the other home and cleared the person out, or if they just voluntarily.
Their intent was to clear both homes, supposedly.
That's our understanding, yes, Your Honor. There was no reports to the Medina Police Department that there was someone unconscious in the home, that someone was in distress in the home. And even after Officer Deeks started to use the sledgehammer and crowbar, no one responded to the front door of the home. Officer Deeks' actions do not even support the claim of an emergency. Officer Deeks testified, and the body camera confirms that he knocked and rang the doorbell for approximately 1 minute. Then he left the home, talked to the neighbors, see if anyone had a phone number for anyone who might have been at the home. He also walked to his cruiser and drove his cruiser up the street during this time period. He was speaking with other officers. He called in the license plate number of the truck parked in the driveway of the home. He walked to the back of the home, peered in the residence, and did not observe any signs of anyone inside the residence. He then walked to his cruiser to get the dog noose. I mean, clearly his intention was to get the dog out of the house, because he walked to the cruiser, got the dog noose, then they came back to the house, decided to use the sledgehammer and the crowbar, and kicked the front door of Mr. Morehead's residence in. Now, the trial court's findings of fact, I wanted to talk a little bit about that. The trial court cited the dangers created by house fires. Clearly, law enforcement is not required to obtain a warrant to establish probable cause prior to breaking into a burning house to save occupants or extinguish a fire. That's clear, Your Honors. However, the trial court cited 3 dangers here, and I want to talk a little bit about those. Number 1 was the possibility of the fire spreading. That was not present in this case. There's no damage to 1021 Sugar House, and there's no smoke in that house. The second danger that was cited by the trial court was that fire can create explosions. Crucially, there's no testimony from any firefighter at the suppression hearing, or fire chief, or fire investigator, which would give us facts to support that conclusion. Officer Deeks testified he was a volunteer firefighter at some point in time, but his certification had lapsed. So there's no testimony to support that trial court's findings that the fire could have created an explosion. The third danger that the trial court cited was the possibility that smoke created by the fire could travel next door and cause problems with smoke inhalation for the neighbors. This is pure conjecture, Your Honors. Exhibit 1 and the testimony from Officer Deeks and Sergeant Wagner were that there was no smoke at 1021 Sugar House Lane, and again, neither officer wore protective equipment. Your Honors, the 9th District has noted that the emergency aid exception to the warrant requirement allows officers to enter a dwelling without a warrant and without probable cause when they reasonably believe, based upon specific and articulable facts, that someone is in need of immediate emergency aid. A case that's cited by the 9th District and also cited by the appellee in this case is the White case. That case is clearly distinguishable from this case. That's a meth lab case from 2008. In that case, the court determined that the danger of fire and explosion presented by the clandestine production of methamphetamine created that danger. In fact, the Ohio legislature also, there was a statute that supported the officers' use of, or the officers going into a house with meth labs as well. And in that case, a search warrant was obtained to search the premises. The same cannot be said for a search of a home that is not on fire and no occupants are present to be saved. Here, Officer Deeks and other officers did not have an objectively reasonable belief that it was necessary to investigate a life-threatening emergency by breaching the front door of Mr. Morehead's residence. Your Honors, in my second part of our brief, we did also mention that the warrantless entry and search of the home was not justified by the emergency aid exception to animals, the emergency aid to animals exception. Appellee did not cite that. There are some cases that talk about emergency aid to animals. The Ohio courts have extended the emergency aid exception to the warrant requirement in cases of animal welfare in very limited circumstances. Here, Mr. Morehead's dog was not in distress. It was not in imminent danger of great injury or death. And if the emergency aid exception to animals applies, animals must be facing grave and imminent peril, and entry must be narrowly limited to only the actions that are necessary to rescue and then provide aid to the animal. I did cite a couple of cases in my brief as to that. The Neanover case in 2021, the dog was emaciated, covered in sores. The deputy in that case retrieved the dog, took it to the shelter for treatment, didn't search the whole house. That's what happened here. The officers breached the house. If they're going to argue that there was an emergency aid for animals exception to the warrant requirement, that the dog was secured, they could have walked the dog out of the house, and clearly the dog wasn't in distress in any event.
Counsel, was there any evidence presented at trial that talked about the distance between the two houses?
I think there was just the body camera and the photographs, which showed that there was some distance. I can't quite recall the exact distance, but there was, in Exhibit 1, you could see the distance between the houses. But there was no testimony that there was any danger from the fire leaping from, I think there was speculation the fire could leap from one house to the other, but again, there's no testimony that there's any damage, either heat damage. I think there was testimony that shingles in 1021 Sugar House were not damaged, that the siding was not damaged by the heat. So any testimony that there was imminent danger to 1021 Sugar House or any occupants was pure conjecture.
And was there evidence in regard to the wind direction?
There was testimony that there was wind, yes, and that the wind could
well, and the wind was actually blowing toward that house, right?
I believe, yes, that's true, yes, Your Honor.
And the other thing I'm thinking is, I mean, your point is well taken in regard to the fact that the house wasn't on fire. You said that, there's no evidence that the shingles were hot or that, any evidence that it was immediately going to go up in flames. But I'm wondering, do you have to wait for that before you try to rescue somebody, or do you think that they're in imminent danger?
No, in these cases are case-by-case basis as to whether or not an emergency exists. Here, the dog was not in distress. There was no one, there ended up being no one in the house, but it appeared objectively that there was no one in the house. And even if they can argue that they could have gone in the house and rescued the dog, the officers went through the whole house, went into the basement, unzipped the divider in the basement, saw that there was a marijuana cultivation operation in the basement, and then they seized that. They didn't go and get a search warrant to search the basement at all. So it's our position that there was no emergency exception here to the warrant requirement, that the trial court erred in not granting the motion to suppress, and this court should reverse the trial court and vacate Mr. Morehead's conviction. Thank you.
Thank you, counsel.
Morning, Your Honors, and may it please the Court, I'm Vince Bellucci with the Medina County Prosecutor's Office for the appellee, the state of Ohio. Your Honors, the fire at 1013 Sugar House Lane was an exigent circumstance that supported an objectively reasonable belief that immediate action was necessary to protect the homes next door. That's the standard. The U.S. Supreme Court has long held that an ongoing fire qualifies as an exigent circumstance. That goes all the way back to Michigan v. Tyler in the 1970s. In this situation, the exception is often referred to as the emergency aid exception. No court in Ohio or anywhere else has held that the fire in question has to be taking place in the actual house that's entered, or that it can't come from a danger in the immediate vicinity of the house. Officer Deeks, as was mentioned, testified that the wind was actually blowing toward Mr. Morehead's house specifically in this case, and that there was significant smoke being blown in that direction. Sergeant Wagner went into a little bit of detail about how it's their standard procedure, consistent with police training, to evacuate people living next door to a house that's on fire. He explained that in that situation, a fire can easily jump from one house to another, and that smoke can get inside the next door neighbor's houses, especially if it's blowing right at the house like it was in this case. So the officers here were not doing anything out of the ordinary that they wouldn't do in every situation, and what they're trained to do. The exigent circumstances in this case, again, were the dangers of fire, smoke, and also explosion presented by the fire next door. And I think that's fairly common knowledge, and I think that's something that a police officer can testify to. That's not something that you need a firefighter to necessarily testify to. I think people understand that fires spread all the time, and that they can spread and they will spread if they're not immediately taken care of. We know that people inside could have been, in Mr. Morehead's house, could have been sleeping, hiding, unconscious. The officers described this fire as a burgeoning fire. They didn't burst right in, as was already mentioned. They did unsuccessfully try to call the owner of the house first, and weren't able to get anybody. And they did see a dog inside the house. We know that courts in Ohio have extended the exigent circumstances exception to situations involving animal welfare. And, I agree with Mr. Martinez, every case is different, but I think and that just illustrates the fact that there are many ways for an animal to be in danger. The animal doesn't necessarily have to be visibly emaciated or dying right in front of the officer. I think a fire next door that could easily spread to a house with a dog in it, that qualifies as imminent danger, as the officers explained.
Counsel, about the reasonableness of everything that they did once within the house. It seems like maybe, obviously you see the dog, I know there's testimony that they heard a radio and somebody else may have heard voices in the house and so forth. But after you've banged on the door, you've called, you've done all this, how reasonable is it to go basically and check everybody's beds?
I think in this case, it's more reasonable than in most cases to search the entire house, because if there wasn't a response to loud banging and commotion outside, that makes it much more likely that the person inside is sleeping, unconscious, hiding, or just in a remote part of the house, perhaps, like the basement, for example. It's very plausible that somebody could have a secondary living space down there and not be hearing all of the commotion upstairs. So that's why it's critical to search the entire house and do a thorough search of the entire house to make sure there's nobody that's in there that could be in danger. And as you mentioned, Judge Carr, this was not just a matter of rescuing an animal in this case. Sergeant Wagner testified that he thought he heard people talking inside the house. Officer Deeks testified that he thought he heard a radio playing inside the house. And what Mr. Morehead basically says to refute that is that the officers are mistaken. Well, their testimony is what it is, and that's what they observed. And also, there was a vehicle parked in the driveway, and I think that as well leads to the very reasonable conclusion that there's somebody inside that house. There's a vehicle parked in the driveway. So all of those things together, I think, are critical to needing to enter the house. The basement here, in this case, was especially interesting, I think, because it didn't take an extensive search for Sergeant Wagner to go down and immediately see that the light was on and to hear a fan. And then he saw what he described as a tent-like frame where he reasonably thought someone might have been hiding or just living down there. So he was immediately drawn to that because it appeared that there actually was somebody in the basement. And that's when, of course, he pulled back that tent-like frame and saw the marijuana grow that was found in this case. I think he reasonably thought that there might have been a secondary living space down there, like I said, and that could have explained someone not hearing the knocking at the door originally, if he was way down there. Again, this search was completely by the book, and it was completely justified under the exigent circumstances and emergency aid exceptions to the warrant requirement. And again, just the State v. Neonover case cited by Mr. Martinez from just last year, the 12th District, cites other 12th District cases, 2nd District, and even 6th Circuit federal court cases talk about rescuing an animal who may be in danger, and that the emergency aid exception has been expanded to that. And again, there are a multitude of different facts that come up in this scenario, but I think a fire is, again, a very serious situation that has to be dealt with immediately. So if there are no further questions, the State of Ohio would simply ask this court to affirm the trial court's denial of the motion to suppress.
Thank you, counsel. Attorney Martinez, you have just over 4 minutes.
Thank you, Your Honor. Appellee cites Michigan versus Tyler. Yes, you can go into a burning house. Yes, you can take life-saving efforts in that house, not into another house. Tyler dealt with the house, and also some of these cases have held that firefighters coming into the house after the fire has been extinguished must have a search warrant. Okay, it's just the emergency that obviates the need for the warrant at that time. Appellee mentions that the smoke can get inside the house. Well, here, the testimony from Officer Deeks and I don't know if Sergeant Wagner testified as well on this issue, but that there was no smoke in 1021 Sugar House. He was not wearing protective equipment. No one was wearing protective equipment out there near that house. Okay, of course, at 1013 they were, but there was no smoke in the house. The windows were closed. He was not wearing protective equipment. That danger did not exist in this case. They also cite the fact that someone could have been sleeping in the house. Well, we can look at other factors here. It's during the day. The sirens are going off. Okay, there's a car in the driveway. Many cars are in the driveway when residents aren't at the house. That's not necessarily persuasive in this case. Talk about the reasonableness of the search. Again, it's daytime. Sirens going off, the sledgehammer on the door, the crowbar on the door. Anyone in that house would have woken up and come to the door and say, well, why are you breaking in my front door? What's going on? I hear the sirens. Let me see there's a fire next door. Somebody's going to walk out of that house. It's just incredible to believe that someone was sleeping in that house. And there was no reports that anyone was unconscious. Why would they be unconscious? There was no danger. There was no danger of smoke inhalation. It would be different if this was an apartment fire and you're evacuating the apartments within the building there, where you have to go in those apartments to make sure that everyone's evacuated in one structure. Here, there's separate freestanding structures. There was no emergency that warranted Sergeant Wagner and Officer Deekson entering that house. We would ask the court to find that the trial court did err in this case, that there's not an emergency aid exception that applies, and reverse the decision of the trial court. Thank you, Your Honors.
Thank you. Thank you both for your presentations today, and thank you both for traveling to Summit County on this snowy day. The court will take the matter under advisement. We will issue a written decision, which we mail to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you, gentlemen.
Thank you.